Thank you. Thank you, Dirk. It's so great to be here again. I was here teaching a course last year on similar themes, but this year, unfortunately, I need to contend to this short introductory lecture. So a couple of words about me. I'm an assistant professor. My chair is called Law and Digitalisation, whatever that means, still trying to figure that out. And I'm also a research director of the University of Helsinki Legal Tech Lab, which is an interdisciplinary research hub experimenting on digital technologies. I have a legal background, mostly in procedural law and legal theory. I did my master's 2010, defended my dissertation in 2016. You might wonder what is trained on the bench. I did a year in the courts as a trainee judge, which is a part of the judge training in Finland, but then have stayed in academia. My research interests are mostly on legal automation and especially legal decision making. And as a part of that, I'm now mostly focusing on fairness-aware AI and algorithmic transparency, different types of governance and conflict management schemes in digital environments. And one of my pet peeves is distributed ledger technologies. And my secret plan B, in case the professorship doesn't work out, is to move to Australia and become a vegan baker. Then I'd like to hear a couple of words about you. So raise your hands if you have a legal background. So most of you are lawyers. Wait a minute, I'll try to remove this. Yes. And is there any IT background people here? Okay. Welcome. And then only one more question. How long day have you had and how exhausted are you? Very exhausted? Okay, but it's been a long day in computational methods. Okay, so bear with me here. I'm trying to make this as easy for you lawyers as possible. Most of the stuff I'm going to be talking about is stuff that you already know, so I'm focusing on dispute resolution. And for those of you who can't stay awake, here is what was promised, and the easy, too long, didn't read answers to it. So I promised to provide you with a comprehensive overview over digitalization of dispute resolution. Long story short, it's a complex mess. Then, rethinking legal practices from a user-centric perspective, fancy words that can be simplified into you need to figure out who's the user you're developing technology for. And then how inclusive legal design can lower the threshold for seeking legal protection. I'm arguing that the promise here is that legal design can help us to fulfill the potential of digitalization, which is actually figuring out what's the problem with law. And how I'm going to do this, I'm first going to tell you a bit about access to justice and what does digitalization of dispute resolution mean. Then I'm going to argue that digitalization is actually not about technology, but about critical reassessment of law. Then I'm going to give you some examples of what are digital technologies for dispute resolution, both functionalities and existing things. And then I'm going to go forward to describing two different forms of dispute resolution which have provided different digital mechanisms, namely online dispute resolution and online arbitration. And looking at the failures and the problems with these schemes, I'm going to go forward to courtroom technology and asking whether with digital technologies we can actually make court procedures easier. But to start with the big question, why access to justice? No one even knows what these words mean. Access, it's a complex word. Justice, we've been trying to figure that out for 10,000 years at least, we lawyers. But I'm going to go to my last week, actually. Last week, I had the pleasure of not preparing for this lecture, but to go mountain climbing in Slovenia. This is Triglav. And I'm showing this to you as an analogy for what is the problem with access to justice. Access to justice in this context, meaning access to dispute resolution. For most people, it makes absolutely no sense to walk on a mountain. But in case you would like to do that, it is relatively straightforward. It doesn't cost anything, or the cost is very low, and it's right there. So basically, you can just go about it one evening and climb a mountain. So straightforward business. Once you get closer, you are starting to be a bit uncertain whether this was a good idea, because you notice that the mountain looks far more scary than from a distance. And then you notice that when you start climbing it, all things start to look pretty bad. The lawyer in the picture is smiling, the layperson is not. I think the difference here is that the lawyer knows how to use the belaying systems. So what does this tell about the legal system and dispute resolution? That it is problematic, that it's hard. People try to avoid doing it as long as possible, but once in a while they might figure out that they have no other alternative than to climb that mountain. As we can see, that mountain is not really accessible. So without the belaying devices, without the knowledge of how to use those devices, you might find yourself in quite a lot of trouble. So what to do about this? The mountain is there, but we want to make the mountain more accessible. I'm saying that there's basically two options to make it more accessible to a lot of people. We can decide to build a road, which, fair enough, takes a lot of infrastructure and construction, but then everybody can go on top of the mountain by one way or another. Another option is that we just dismantle the mountain and start again, and perhaps build an escalator for it. Both of these options take a lot of work. Both of them require that we first figure out what is the access problem and who is that access meant for. Is it made for people with wheelchairs, with people with crutches, people who have absolutely no mountaineering skills? So what is access and whose access are we talking about? And the solution, whether it's a road or whether it's a dismantlement, depends on whose access problems we are trying to solve. When we take this back to access to justice, well, we all want to make law work better because it's very frustrating when law doesn't work, also for the lawyers. But how do we do that? What does access to justice even mean? And Wikipedia, which is the truth into what exists in the world, I think proves the point very well. So the article on access to justice does not tell us anything about access to justice, but instead about a human rights organization in Nigeria. Making sense of the access problem. So, if we are saying that there's an access to justice crisis, if law is not accessible, what do we mean by it? How do we measure access to justice? Either the fairness part, which would be justice, or the access part. When we start to look at the literature, how typical access to justice problems are portrayed, we see that there's a lot of themes that are repeated. A lot of these are called threshold issues, so the fact that it takes a lot of money, a lot of competence in order to first even start thinking about going to courts. Courts are costly and time-consuming, so is arbitration. There are alternatives, but those alternatives have different shortcomings. Also, one problem is distrust and unclarity of legal rights and obligations. So especially laypersons don't necessarily know whether they have a case to go in front of the courts for. That's why they're paying us lawyers a whole lot of money. In some jurisdictions, corruption is also an issue, an access to justice issue, and in most, I'd argue in all jurisdictions, bias, especially unconscious bias, is a problem. But if we start to look at the problem, which is accessing justice, whose problem is it anyhow? Courts are only a small part of this problem, and of course, courts being our primary idea of what is dispute resolution, they're a very definitive one. But if we look at most jurisdictions, the cost of litigation is not dependent so much on the costs of actually accessing the courts, because that is subsidized by the governments, but it's about legal fees. So part of the problems is also law firms. One issue is, of course, the relationship between law firms and in-house counsels and how that affects the invoicing models. Another part of the puzzle is self-representing litigants who decide not to hire a legal counsel, but instead want to represent themselves. And of course, governmental organizations, especially those who are helping, for example, consumers, well, they bear part of that problem. So we can see that threshold issues can be caused by a lot of different reasons. And of course, when we start to think about how to solve these problems, it depends on the perspective. Are we talking from the perspective of law firms? How to make legal working law firms better in a sense that would also lower the costs and the time-consuming practices, or are we focusing more on the laypersons? And another problem related to this when we start to add technology to this, because technology is not a problem yet in my description of this access to justice crisis. But once we start to think about what type of technology are we implementing to dispute resolution and how, we notice all types of different structures that are making it difficult to implement and develop that technology. Resistance against change, this is one that is often quoted, especially in relation to lawyers, but I'm not buying into all the lawyer bashing that's going on, especially in the legal tech scene. But there is definitely a resistance against change happening. Part of that is well defined, and there's a good grounds for that, but still. Another problem, which is especially related to public IT procurement, is the lack of technological understanding, which also leads to IT projects becoming bigger and bigger and being delayed. Legacy software, another issue. And one of the problems is also that when we start to implement digital technologies, especially in the courts, we very much focus on the cost savings, so fiscal efficiency, which when we look at studies is not necessarily the best way to go about, because rarely such huge IT projects actually bear that much cost savings, but the point is more on the quality side. So just a couple of words of definitions. Digitization and digitalization shouldn't be mixed, because with digitization we are actually talking mostly about transformation of analog data to digital. This transformation of data is then contributing to digitalization of the society, with which we actually mean the societal change and the social implications of information technology. Legal tech, which you are learning this whole summer school, originally referred to software for law firms, but now we are using a much broader definition of that word. Two other words, courtroom technology, an older word, and dispute resolution technology, which I'm using in the sense of umbrella for all IT that is trying to facilitate conflict management. Boundaries are blurry, there's a lot of overlap, and this also contributes to the fact that this is a messy business. But none of these challenges and none of these solutions are completely new. So this is an article by Lee Lovinger from 1949, where he's saying exactly the same stuff that we are saying now in the legal tech community. The mystic ritual of this cult is announced to the public, if at all, only in bewildering jargon. Daily the law becomes more complex, citizens become more confused, and society becomes less cohesive. Of course, people do not respect that which they can neither understand nor see in effective operation. So the lawmongers bemoan the lack of respect for law. Now the lawyers are even bewailing the lack of respect for lawyers. And that's something we never want to see happening. What's out there? This is just the startup map from Legal Geek Conference, but that shows that there's a lot of different startups, a lot of different software that could be used also for conflict management purposes. But the reality is that these are the most important legal technologies lawyers are using on a daily basis. What is this gap? What do we do about this gap? Once we see that Google and Dropbox and Word are the most important legal technologies, this starts to be a utopia. How do we take dispute resolution, which is an inherently oral hearing, and digitalize that? That's a challenge, especially because there is the question of how do we do this remotely? Is that even feasible? Or what are we talking when we are talking about digitalizing dispute resolution? A spoiler for a bit later on, well, we don't. This physical thing is probably one of the only things that are really hard to replace, but that doesn't mean that there isn't a lot that we can do. Also, this is a false description of what the courts actually do, but I'll get to that in a moment. But this is all to say and drive home a very simple point, which is that dispute resolution technology is not about technology. And understanding where this complexity, where this mess actually comes from, it is important to understand the diversity of different application domains. Are we talking about the courts implementing technology, arbitration institutes, providers of alternative dispute resolution services, legal aid offices, governmental organizations, or something else? And for what purposes? Are we trying to implement technology to aid in that first step of figuring out whether there's a case or not? Or are we talking about conflict prevention and compliance? So what is excluded and what is included? Access to justice is not efficiency, and it's neither only due process, but access to justice has this idea that there's also a material component to it. But due process is a handy way to start thinking about what would the justice mean in this context of dispute resolution. And there we come back to that trial photo I just showed you. So the question of procedural justice, that due process, and in this sense access to justice, is not simply about whether to follow certain procedural rules, but it is also about the right to be heard and that idea that one can speak one's mind or actually get the impression of speaking one's mind during a court hearing. Also, due process requirements are closest way to start thinking about justice in this context. They vary depending on the process. So if we have an adjudicative process that ends up with a binding decision, like online arbitration or court proceedings, it's a very different type of due process requirement than for mediation or conciliation. And of course, the whole bigger picture here is the changes of legal institutions and professions in the aftermath of digitalization, how legal markets are regulated, how legal business models are developed, and how this network of different actors, both private and public, collaborate in providing dispute resolution. Digitalization as critical assessment means looking at processes that we have developed over hundreds of years, over thousands of years, some would argue, and those processes are often developed organically, although codified, then tweaked a bit, then codified again. But it is not like we just started to develop a legal system and a court system from bare bones and build it up as a coherent, nice, easy system to use. This type of critical reassessment means asking, what are these legal processes that we are even thinking about digitalizing here? What elements of these processes are actually fundamental for the stuff that we have these processes for providing legal protection? Which elements instead are redundant or even harmful for effective access to justice? And how do we go about identifying what is functional and what is dysfunctional, especially because these problems are very often defined based on the context and jurisdiction? I think it helps, especially when we start talking about digitalization, to think of dispute resolution as information management. So this idea that there are different ways to produce information, which is then used to come up with an outcome of that process, which hopefully is always a settlement between the parties, because an adjudicative decision is the worst solution possible. And this all is to explain basically that we can implement different information technology in very different stages of dispute resolution. Some of those are more focused on conflict prevention, and in that sense, access to legal information and triage is an important aspect. Complaint management as well as conflict de-escalation, and then we move on to conflict resolution side. So there are different functionalities of technology range from e-filing and case management to remote hearings, electronic evidence, and completely digital appeal processes. And of course, the specific functionalities, they depend on the process, like I said, and the case type. Also, it's important to distinguish which cases can be completely automated and which are those that we consider requiring human intervention. And like I said, it's also about the question of how do we create a sense of being able to say one's mind. There's a lot of different applications that people are now experimenting with, but I would advise that the most important thing is to focus on what are we actually trying to implement the technology in, and what is the function that we want that piece of technology to take care of. And who's the end user? That's another way to start going about thinking what technology should be developed in order to address the problems, and whose problem it is to find the solutions. Different groups who are the end users of different applications have different needs. This is very obvious. Clients need very different tools, self-help, negotiation, access to legal information, and court personnel have very different needs. For judges, they should also be separated from the court personnel, and in this I mean judges as well as arbitrators, and there we have all different functionalities that could be supported by technology. And for lawyers, of course, working especially in law firms, the needs are still different. So, what have we learned up until today? We have online dispute resolution, which was the predecessor of most of this discussion that we are now having on digital conflict management. Online dispute resolution originated in alternative dispute resolution, which means out-of-court, non-binding dispute resolution. The idea behind ODR was originally to address internet disputes, especially those emerging in e-commerce, so cases that are of very low value and high volume and often cross-border by nature, which will all naturally stay below the court litigation threshold. We've been discussing ODR already in 1990s, and the role of technology in ODR processes, well, it can be whatever, which is understandable when we look at this long history of 30 years. So, in early 1990s, email was considered to be online dispute resolution, whereas later on, some scholars consider that only completely automated dispute resolution processes should be called ODR. This particular dispute was settled in 2016 when this very inclusive definition of ODR was provided, which basically means that ODR is anything that might somehow have something to do with information and communication technologies. eBay is the most successful example of ODR that has emerged, and according to some statistics, eBay solves over 60 million cases annually through their resolution center. This is made possible by the fact that eBay has a very close connection with a payment interface in the form of PayPal. Another example, ICANN's uniform domain name policy, which provides similar service, some of these processes being more digital, some a bit less. There are a couple of legal regimes that try to govern online dispute resolution services, national legislations, and the EU has ODR regulation, which sets a EU-wide platform for online dispute resolution, and also UNCITRAL has tried to create technical notes to govern, for example, due process issues in ODR. This is a picture of the Commission's ODR platform, which starts with a very rudimentary, simple triage of figuring out whether there's a case that would fall into the jurisdiction of the Commission's platform. There's a diversity of ODR providers that are linked to this Commission's platform, and once a case becomes pending on the platform, then the case is forwarded to the national ADR body, which have been listed on the website. How many of you have ever heard of the ODR platform in the EU? Okay, this is better than I usually get, which is sad. Well, there's a lot of problems with the ODR platform, and the EU is now considering of making some changes to it. One main problem being that the outcomes are not binding, and it is very impossible, very difficult to get traders commit to the resolution processes, which means that most of the claims that come pending actually are then just forgotten. When there has been such a strong push towards ODR, both in the UN level and the EU level, why haven't we heard of ODR? There's a lot of reasons, but I'd go with these, saying that there are several. So I'd argue that the whole idea of online dispute resolution is still too complex and too lawyer-minded. So there's still this idea of just creating a digital courtroom and then figuring it out using the same methods as we've always done. And of course, none of these solutions are very user-friendly, and a lot of consumers do not know about it. And I'd argue the same thing that the Commission has said, that one of the problems is that there is no stick or carrot to get traders on board. Then online arbitration, another one that has failed, actually. So there are some applications. There's a lot of discussion what is the difference between electronic online arbitration, what is mediation arbitration, does anything of this matter really? Well, one of the things is that it matters because the arbitration community, of course, wants to hold on to the enforceability of arbitral awards, and that means abiding to the rules of the New York Convention from 1958, which might be problematic at times. There are some things that have emerged, and ICC has actually been trying to push for online arbitration, and although there are more online repositories and use of email, everybody does that in arbitration proceedings, still, well, nothing seems to happen. There's this one cool thing, though. So something that the arbitration community is trying to do is that they're trying to develop also digital tools to help to make the pool of arbitrators in international commercial arbitration broader, and that's why they're using, for example, just collecting information about different arbitrators. So as you can see here, it's very, very, very rudimentary in a way. Of course, there's some rules developed for online arbitration, but as far as I know, cases in most arbitration institutes that have online arbitration rules, well, they are next to non-existent. Why? Well, some scholars have suggested that interpretation of the New York Convention is one reason, and then again, where's the need? Because international commercial arbitration is often $1 million or even $1 billion business, there is no similar need to develop online tools as for low-value, high-volume e-commerce cases. Some argue that cases in online arbitration are too complex, and others are saying that, well, why take the chance of using online tools if you don't need to? Of course, there's also commercial services that aim to lower the threshold for dispute resolution, Flightride being one very often quoted example in these circles. But also blockchain. Last year, blockchain was a buzzword. Now it's sort of paused, but I wanted to raise this point just to actually, well, because it's my pet peeve. So the blockchain was supposed to be the technology that gets rid of conflicts and hence also gets rid of the need for dispute resolution schemes. But as we can notice from different types of blockchain-related disputes and from the emergence of all these blockchain-focused dispute resolution service providers, well, the blockchain was not able to do that. There are still disputes, there are still need for dispute resolution, and now the question is, how do we provide that both offline and online? The question cannot be answered in any satisfactory detail as of yet. Then a bit about courtroom technology. The problems with courts are easy to point. Mostly they're easier to point than in arbitration or mediation because of the public interest and the public dimension of court procedures. But once we start to think about, well, what are the solutions? We need to figure out what do courts actually do. This is a handy forefield provided by former judge Dori Reiling, who was looking into civil procedure in Dutch courts in her PhD, and she figured out that actually courts do not mostly do what we think they do. So we think that it's about court hearings, setting the court date, but once we see this Dutch data, we notice that actually the top right corner is the amount of cases and amount of working hours in Dutch courts which is spent in contested civil litigation. Mostly the courts provide completely different services, from producing enforceable titles to taking care of notarial duties or providing different means for the parties to reach settlement by themselves. And if we start looking at these different functionalities of what the courts do, we notice that in these different areas, very different technological tools are needed. For the settlement, well, negotiation tools apparently. Well, obviously. For title, well, just easy automated procedures that produce enforceable decisions. And for the judgment, well, that's the tricky one that most of this conversation has focused on. Potential is obvious, but, and like I said, it's mostly on improving the quality of decisions and not simply about cost savings. And that is the tricky one. But of course, when we start to think about this in very broad utopistic terms, we also start to think about public courts as part of a networked legal market, which is collaboration between law firms, legal aid offices, arbitration schemes, mediation, conciliation, and all of that. One of the points that court IT could do is improve customer service by, for example, this type of triage services, or by chatbots. Litigation IT for lawyers is a very different thing, and there we can see, for example, litigation and strategy tools, which has led to one of the most recent discussions in this field, where France decided to ban judge analytics when it turned out that some French judges are, well, a bit racist in deciding certain cases. San Francisco decided to go the other way around and decided to take an algorithmic model and start using analytics to actually figure out racial components in their decisions to prosecute. And evidence. And another big one that we've been discussing for the last 5 years a lot is this predictive tool, which is used in some US courts to decide the recidivism score of criminal defendants, which turned out the algorithm actually has racial bias. And this led to a whole lot of uproar in media and a whole lot of ethical documents that now try to address this problem. One of the discussions here is that, okay, it's a black box algorithm, what do we do about that? But something that is often forgotten in these discussions is the fact that we don't really see in the head of the judge either. So it becomes a question of which black box do you prefer? And the answer to that question depends on the situation and on the person. A couple of weeks ago at an AI and law conference, we actually asked this question of the audience, and, well, it varies a lot. It depends how good your judge is, what you personally prefer. But often when we are making these comparisons, we mystify human thinking and consider that to be somehow better. Or the other opposing discussion is that we believe that technology, by the virtue of being technology, is objective. Both of these are false, of course, because human action is always, well, subjective. But, so a bit about algorithmic decision-making from the legal perspective, because I do believe that this discussion that we are having now on algorithmic decision-making is actually one of the most fruitful ones that we can have in the context of digitalization of dispute resolution. Like I said, access to justice is elusive, but it is one of those criteria that we have, and kind of like following that criteria is still a very safe way to go. When we overlook a lot of these problems that have been elaborated in the literature ad nauseam, we notice that the potential of algorithmic decision-making is that we start to understand human decision-making more better, and we are also able to start thinking about new monitoring schemes and better decision support schemes. And we can think of a utopistic future where all the routine cases are automated away and we can better allocate the resources to those actual cases that demand legal reasoning, and also those court hearings where human component is vital for the communication and for the information management. And one of the things that are often also raised is the idea that when we start to automate certain types of cases, we also start to standardize working methods. This is not only good or bad, but instead it's both. But I would argue here that it also means that our legal practice becomes more predictable, and that helps us to develop better conflict prevention tools, because conflict prevention, like all of you know, is much cheaper than dispute resolution. Also, I'd argue that we should get rid of the dichotomy and juxtaposition of human and algorithmic decision-making and start thinking about side-by-side implementation. So the idea of how can we improve decision-making in general by using both systems and humans together. Of course, there's the danger of rubber-stamped judges, the idea that we just have a human in the loop who just presses a button and there's no actual legal review there. But that is also a question of how do we organize this interaction. Another issue is gamification. And that is something that a lot of court digitalization projects are looking into right now. What parts of such collaboration can be gamified and should be gamified, and what should not? But I think the potential here lies in function allocation. So combining these two. This is a picture from Fit's list, which is my scapegoat for a lot of the dichotomies and the juxtapositions and a lot of this discussion about why choose between human or a machine. It originated in 1951, actually in aviation security. But we can still see in a lot of discussions on legal technology that people are still referring back to this list, which had a very rudimentary sketch, not meant for general public, actually, that lists what are the tasks that humans are better at and what are the tasks that machines are better at. And here we can see again that contrast existing. So I'd say let's get rid of this idea and start thinking about combining human and algorithmic systems. And to end on a positive note, I have a couple of words about legal design. Legal design is it's entwined here in a lot of the things I've been saying, but here's one really interesting project that you might want to look deeper into. This is a project from Margaret Hagen's Legal Design Lab at Stanford, where she has been developing with her team a court messaging project which actually helps self-representing litigants to know what they're supposed to do when the mountain is there and they are supposed to go in front of the court. So what does it mean? How do they prepare for that? And how can they be coached for handling the emotional stress that is related to going to the courts? And one of the big questions that we are now asking in the access to justice community is that are we going for access to justice by car or by bus? Our idea up until now has been that we have a single person who is accessing dispute resolution, and that is what we should have in mind when we are talking about legal protection. But the alternative, which I think comes with a lot of promise, especially from digitalization, is the idea that why can't we take a bus? So why not get rid of this individual legal protection and start developing more collective schemes and more European collective schemes? So I'm not now referring only to class actions in the US sense, but rethinking new systems. And for example, in the EU, some of the discussions we are now having about platform conflict management is actually going a bit in this direction. So, the mountain. What if we don't dismantle it? What if we don't ruin it by building a road? But what if we start thinking about different ways how to take into consideration the needs of different groups and perhaps come up with a choice, an array of different options to get on top of the mountain. And here I end. Thank you.
While you guys are busy thinking about your questions, I hope I didn't overlook anyone. I'll ask the first one. Can you go to the slide of the Civil Rights Tribunal in British Columbia? I think it's in the 50s or 60s. Yeah, nearly there. There we are.
Yes. Sorry, I wanted to rush a bit so
okay.
that we'll stay in schedule.
It's the Civil Resolution Tribunal, and that really impresses me. I don't know how much you guys know about this, but I think this is the right direction. He is not reforming like courtrooms, equipping people with better tools to maybe summarize the facts or something. People in British Columbia just took part of the disputes and claims they wanted to handle and created a new tribunal. They handle everything up to 5,000 Canadian dollars, which is something in US dollars, I guess. And they also handle particular housing disputes and now start handling personal injury for motor vehicle disputes. And they do it in a completely new way. Rules are very simple. Everything like this, I don't know, in Germany, this 400-page user manual that we call our Civil Procedure Act has rules for everything and anything. And this is very light. Turns out they do it with 13 people or something. Not all of them have to be actual judges, they're just lawyers. And I would like to get your perspective on, maybe we're thinking all of this an order of magnitude too small. When we think how can we make courts better and how can we help judges, maybe it's really time to just start new and say, so this is what those guys did, I feel. And I'd be interested to hear what you have to say about that.
I love this question because I think this is a wonderful example. I don't think it's starting completely new. I think it's actually one of the reasons why this is such a delicious example is that it's completely built on the existing court system. So although this is often described as an online dispute resolution tool, it is governed and managed by the courts, which means that at the same time it has the backing of that authority and that enforcement mechanism. So a decision that is done on this platform is actually enforceable by law, which means that it overcomes a lot of the problems that I would assign to the more traditional private ODR schemes. I think it's also wonderful how they started going about this. So they first mapped out what is the user experience of citizens. And that was also possible because they didn't have the idea of taking the whole of civil procedure, but they started with a very a narrow set of cases which are typically those that are, well, self-representing litigants, which also sort of limits the complexity needed in order to start doing something like that, and then starting to build from there on. And what I say that little goes a long way, I think there's, as far as I know, and I've heard a lot about this particular example, there is no fancy machine learning technology, blockchain, AI, hand wave behind it, but instead it's a very simple questions, answers, interactive forms, guided path, a lot of user testing with different groups that actually made this into being. So I'd say it's actually very like grassroots level, very simple, but then when we start to think about its implications and the scalability of this, then I think that we are actually reaching for the stars.
Yeah, so one of my inspirations to be a lawyer was when I was a child in the 80s watching this TV show, People's Court. I don't know if it was, and it was just, they could avoid court fees by going on television, disputing their little small claims.
Ouch.
And yeah, it's fantastic. But similar, I wanted to hear about you kind of briefed over how digitalization is going to change sort of a rethinking of legal practice in general and sort of how we approach this. And I think I'm a little different than you in how I'm actually a super enthusiast of blockchain. And I was thinking about this so a people's court in blockchain world, and how we might be rethinking who decides cases and really coming up around more ideas of community justice and letting sort of online blockchain-based community members decide people's disputes that are really under a certain amount, and there's not much of a legal risk. I mean, there's not much of a financial risk of making legal errors and making those bindings through systems like this that are backed by courts. Thank you.
Person. And then
okay.
I mean, you don't have to, but it's an idea.
Okay, that was probably a bit too provocative. Don't get me wrong, I'm very interested in blockchains. I've been doing some research on the topic for quite a long time now. I think it's a treasure trove for an academic, at least. I think what you describe is actually interesting. And that's something that we have seen already for decades in different online environments. So for example, when we start to think of World of Warcraft, so user-generated conflict management is something that has emerged there, for example. And we can see a lot of different applications of crowdsourcing decisions. Obviously, I think there's a lot of shortcomings there, especially if we want to think in terms of due process. And I think that one of the really hard decisions there is that where do we draw the line? So which are cases where we consider that, okay, anything goes. We don't need to worry about there being like a material legal reasoning behind, or we don't really need to worry about how these individuals who would be then crowdsourced, how they're coming to their results. And because the danger then there is that we have like several layers and several different solutions for how fair the dispute resolution process is, and who wants to draw that line. This being said, that I think that right now in the blockchain community, one of the reasons why I think it is so interesting is that because it is so challenging to resort to the existing offline dispute resolution mechanisms, there has been this strive towards developing completely new mechanisms to solve those issues. I actually did some research on this earlier this year, and there's basically a lot of different variety of how this is done. Some blockchain dispute resolution actually goes for crowdsourcing, but most of those that I am aware of are actually limiting the pool of who gets to decide. Others actually have decided for off-chain conflict management, meaning that they want to sort of take the dispute resolution off the chain and then just sort of put the enforcement, so develop an interface between the on-chain enforcement and off-chain dispute resolution, and a multitude of other versions. But luckily, I'm not the one who needs to decide this. I just get to do the research and see what's coming up. There's one, and there's second.
First of all, congrats on climbing Triglav by Northern Ridge, which is, for everybody else, highest mountain in Slovenia, from where I'm from. Second, to the question. So in terms of improving access to justice through electronic means or digital means, how do we bridge the gap? How do we solve the conundrum that a lot of people who are denied access of justice are less sophisticated in digital world, maybe perhaps older, alone, or from underprivileged backgrounds without the proper knowledge or access to digital tools that would help them. So how does these two ideas go together so that we help the people that need this the most?
That's a very difficult and a very good question that a lot of civil justice systems are now struggling with. Of course, because the problem that you're raising here is also that if we decide to go completely digital, then we need to take into consideration the digital divide. So, because the fact that if everything is digital, then it's up to a citizen to be able to do that, and people just aren't that tech savvy to begin with. I would also then again ask whether all millennials are that tech savvy, but that's a different discussion I'm not going to go into right now. I think there's no easy solution to this question. A lot of systems are developed at the moment with side-by-side, so that there's also offline options for people that want to resort to those. Of course, if we want to push for digital means of accessing the courts, for example, then the question is, how do we encourage digital without punishing people who do analog? This being said, I think some of the solutions are actually that we shouldn't be thinking about digitalizing everything. And also we should think in terms that if we free these human resources that do a lot of repetitive tasks in the courts, well, how about if we put those human resources into actually helping people? And I think some of the wonderful work that Margaret Hagan is doing in Stanford is that she's actually saying that with digital technologies and legal design, we are not trying to remove the human from the equation, but we are actually trying to put the human where the human input counts. So to help with all the fears and all the anxieties and difficulties that are always associated with accessing the legal system. And I think that would be something that we should focus on. So kind of like the emotional support, coaching, and all of that.
Thank you. I had a question about access to justice problems in commercial arbitration. A hot topic in the past few years has been how to solve the situation where a small to medium-sized business has a case against an Apple or a Google and knows that if they start any kind of proceedings in arbitration, they are just going to ask for security for costs or like bury them in documents, and it's not going to be cost efficient anymore. And something that has become a hot topic is third-party funding. And everybody in the arbitration community either hates it or loves it, this idea. So I wanted to ask what your view on that is, and if you are a fan of the system, whether legal tech can help encourage that process by, for example, starting systems like GoFundMe for my proceedings. What your view is on that?
That's a good question. What do I think about this? I'm not sure if I see a problem there. I argue that is already something that is happening, and it's just a question of how do we institutionalize it? Because how these things usually progress is that things things develop, and well, then we sort of figure out what the legal framework was, sort of as we go. I think the problem that you're addressing, so huge platforms, small SMEs, there's a huge power imbalance there that, of course, is problematic because most procedural justice systems aim to leverage exactly such power imbalances. That's why we have due process criteria, so that the big giant can't just trump over the small litigant. How would you go about it in particularly the platform context? Well, I think that there actually the European Commission is doing something that is most definitely will be an example for what is the direction that we are going. So there, for example, the trialogue between the authorities, they came with the Crown decision idea that different advocacy groups for SMEs would have the right to sue or go forward with a claim on the behalf of a lot of like small platform users. And there the idea is exactly to protect the small SMEs and actually develop a governance model that would bind the big platforms for something like that. I think collective redress is the way to go here. How that actually relates to funding, I don't dare to say what the specifics would be, except let's see what's going to happen and what makes sense. But I don't see a fundamental problem in third-party funding.
Okay.
I think here was a. Yeah, I come from Finland, which is one of the most like gender equal countries in the world. So, thank you.
Thank you. Actually, I was just suggesting two solutions to two problems, and maybe we can discuss about them afterwards. As for the first part of problems with enforceability of the decisions in the online dispute resolution, I know there are some models that use contracts, meaning that parties agree that they are going to enter a dispute resolution, alternative dispute resolution, and insert a clause in that contract that they will abide by the solution. And if one of them does not observe that clause, they can go to regular courts. And as for the question my colleague asked about how do we manage to compromise between lack of availability of online and internet access for underprivileged people. I know, I think somewhere in Africa, I think it was in Uganda, a solution was proposed. It's called the Barefoot Law, I think, and it had the hypothesis. Actually, yeah, the hypothesis was the fact that many people, especially in Uganda, unsurprisingly, have a phone. And therefore, okay, you don't have maybe you don't have access to internet, but nonetheless you have a phone, you have access to the telecommunication network, and you can get help through that phone. And therefore, I think we can adjust to the technology available and try to find a solution for even underprivileged or maybe vulnerable categories of people.
Excellent points, both of them. I'm happy that you raised the African example. So some of the successful ODR examples from Africa actually rely on the existing tribal traditions, where tribal councils have a very important say in how daily life is organized and how conflicts are resolved within the communities without accessing what we would consider the official court system. And the idea has been to use mobile phones that are connected then to this like social enforcement element that comes with the tribal council. So, and I agree with your point completely, so that we don't necessarily need to go with the most top-notch, fanciest technology, but little goes a long way. So mobile phones is a good idea, and for example, very simple Q&As or interactive forms. We often tend to overlook these because they're not fancy, but they might be very, very effective. On your second question, so which was about online dispute resolution clauses in an original contract that would then sort of solve the problem. I'm not convinced that that would solve the problem. First of all, because most ODR schemes, they do not prevent going to the courts in the first place. Neither does ICANN's domain name policy. But the problem there is that the threshold for court access is often too high to be an actual deterrence effect. So it's sort of like scaring someone with something that they know you can't really scare them with. But that being said, I think that one solution, especially if we want to increase online arbitration, is to start actually including contractual clauses that are much more elaborated than just saying that, okay, if conflicts emerge, we'll go to arbitration, perhaps at this institute, but instead sort of have that discussion what that would mean already beforehand. But still, it would solve some problems, but there's no panaceas.
I'm not good at it.
Thanks. Thanks a lot for your presentation. My question is sort of twofold. You mentioned the case in France, how they've banned it and sort of posed, okay, you're going to go 5 years into jail if you start doing this, to which seemed like a very good initiative to try to allow people to have this access to the legal system and to make things more transparent in a way. And my question is, how do you think we can get the incentives right with not only trying to get people to get access, but also convincing members of the judicial system and people in the government as well that this is the right thing to do, that allowing these processes or figuring out a process to get people to have these access, to digitalize maybe the legal system or the judicial system, that it's worth it. And I go a little bit extra. I come originally from the Dominican Republic. I'm now living in Germany, but to be honest, we've got a corrupt judicial system in many countries, including the Dominican Republic. Not all judges, but it is a fact. How do you convince these judges or people in this system who would be affected, whose incentives right now would be affected by something like this, that this can work? I mean,
like I said, I think problems are so very context dependent that it's really impossible to say general answers. I think one thing with corrupt systems is that then I think that one possible solution might be to introduce more top-down solutions than bottom-up, because if it's dependent on a single corrupted judge whether something is digitalized or not, well, like you said, it's not going to happen. But coming back to the European perspective and your question of how to generally incentivize the judiciary to do this, I think they are incentivized already. And this is actually based on a couple of court digitalization projects that I've been following quite closely. So most judges, they like the idea of doing a good job and being fair and not spending too much time with tedious, repetitive tasks, but actually having more time for the actual cases that they consider to be important. So I think the incentive is actually already there, and then it's a question of how do we do that? And the experience from Finnish court digitalization project, I think, is actually a very good one, because originally, of course, because court personnel, they have experience only with 1980s legacy systems, which are horrible, and their idea is that, okay, if we're just going to take this rubbish out and replace it with as bad rubbish, I'm not in. But once you actually start thinking in terms of legal design and in organizing those design projects, you can actually change that resistance, because once you actually start to listen the needs of the users, and give them a bit of empowerment, if you wish, and say that, okay, now you're following the deadlines on this really complex post-it system that is on your windowsill. What about if we'd automate the whole deadline system from you and you can do something better? How do you want to automate it? What would make sense for you? What type of information do you need? And then starting to develop one patch at a time and actually starting with the user's needs instead of just defining like 5 layers further up the hierarchy what is needed by the clerks and judges. I think that comes with the promise that they can do a good job.
I think this will be to the advantage of everybody that I get it back, because in just a few seconds I'll announce that we have a little catering and drinks back there. Before that, I want to make one comment though on what we heard about Uganda. And I'm fully with you that using mobile technologies and not relying on desktops, and there are good examples in Africa, but the idea of using these tribal structures gives me deep trouble. I mean, it takes, like in some cases, it takes over 20 years to get a civil court judgment in Uganda, and that's why people turn to their social structures to solve this. But this seems not the direction we want the world to go in, that we build a system in a democracy that's working so bad that people just say, hey, what about these old men in my town that have decided about people's lives before, right? We should ask them, I don't know, whether I can get a divorce or who owns that land. So I guess there is an element of democracy there that these mechanisms, and I'm the last one to actually be skeptical about any of this, but this can be used in some places to circumvent established democratic structures, and that probably goes to the blockchain example earlier also. We have people who decide about things, and typically they are voted for, and they have to be re-elected, and we somehow access control over that. So I hate people who don't ask a question but simply make a comment. But so how do you...
this is a good comment.
There we go. But since you know a bit more about that than I do, what are the safeguards against these systems being taken by a few powerful people that just don't like the people who are in charge right now to impose their opinion on what the legal system should be like?
What are the safeguards to make sure that a system is not used for malicious objectives? I'm not sure whether we can actually decide upon all of them and develop a foolproof system in this perspective in advance, like recent developments overall have shown. If we go back to kind of like whether to support such alternative social systems or to put money in developing official systems, I think it can be either or, because I would like to see the dream of the 60s, 70s access to justice movement actually be fully realized. So the idea of multi-door courtroom, so where conflicts would, depending on the needs of that individual conflict system, become pending where it is easiest and then escalated further on, whatever is needed in that case. So I'm not for very separate systems in that sense. I think it's a question of interface between official and unofficial systems. This being said, I do understand the problem if we crowdsource everything or if we overlook investments in official systems because there's a safety valve that works well enough. Of course, it is also about the question of what types of disputes or cases would such unofficial systems deal with. So for up until now, at least, we've seen a very strong push for alternative out-of-court dispute resolution. And I think there is something to be said for that push in the sense that let people decide how they want to resolve their conflicts. So we want to empower people, and we don't want the courts to just rob their legal disputes and say that, hey, okay, you were about to settle, but you have a case pending, you can't settle anymore. But of course, it's always like a balancing act between how do we go about it. I would say that the solution that we have now, that we have beforehand decided that certain cases, certain groups of cases are such important cases that if there's a conflict, it needs to be done with state intervention. For example, child custody cases in most jurisdictions are such cases where it is considered that if the parents do not agree on what is the best solution, well, then it's not just some guy from the street who gets to decide and make an enforceable decision on that, but instead there needs to be like this public control that the child's best interests are taken into consideration. And similar systems or similar procedural safeguards we see also in labor cases, for example, or in some other classes. So I think it's impossible to say for sure what would work in all cases, and it's a lot of political decision making that needs to be done in order to make this coexistence of several dispute resolution systems a viable solution.
All right, everybody, I think we can bring it together for Riikka, and then we'll have drinks. Thank you.
Thank you.